Okay, so we will follow up with Matthew on his presentation now. Matthew, the floor is yours. You can continue.
Thank you. So can you see the presentation here?
It's coming. Maybe on the other screen. Okay, now we can see it. Wonderful, wonderful.
Okay. So in the first part, this will be the third part of 3 covering the whole presentation. The first part, we looked at a general summary of the case. In our most recent part, we looked at what does the law actually require of EI decision makers, and we began to look at this process here. How did they engineer the decisions at each step along the way? And we had looked, the last thing was at the BE-Memo. So we can get into that more in our question and answer period, which we will have a separate session looking at solutions, what we can do, and answering common questions. And again, we have lots of information, including the BE-Memo on our blog. Everything is linked at the bottom. The important thing is that a secret memo was issued that coerced EI decision makers at Service Canada and the EI Commission to use new processes with new legal tests and new legal definitions that did not exist before, like changing the definition of suspension, leave of absence. They invented a situation called exceptional circumstances that exist nowhere in law. And that was their justification. Because we have a pandemic, we can just override the law with this secret memo. And of course, Vavilov, the Supreme Court, says it is unacceptable for decision makers to expect their decisions to be upheld on the basis of internal records that are not available to that party. So that closed off Service Canada. I want to briefly look at the EI Commission. There was another very serious problem that took place there. So again, if we go back to our map quickly, you can see after your employer separates you up here at 0, you proceed to Service Canada. If you don't like your answer, you apply to the EI Commission, which is the appeal inside Employment Canada. And then if you do not like your decision there, you can appeal to the Tribunal, which is an independent agency. Also under Employment Canada, but they're completely disconnected. And they also have 2 levels of hearing. I want to briefly discuss what happened here in between the EI Commission and the Tribunal. Because I believe this is egregious. So in our EI Commission record, we had 18 statements from 4 different sources, all saying that we were on a proved leave of absence. When we applied for reconsideration to the EI Commission, they changed their answer. And they actually said that, no, you were on a proved leave without just cause, is how they worded it. But of course, if you do just cause analysis, they have to look at whether your employer is acting contrary to law or unilaterally changing your contract. And they didn't do that. So they knew that when we applied to the Tribunal, their decision would have to be overturned, because if we're on leave without cause, but you don't do the cause test, then how can your decision stand? So when we applied to the Tribunal, the EI Commission, in their arguments to the Tribunal, sent this. The attention of the Tribunal is drawn to the fact that a clerical error was made in the notice sent to the claimant. The notice indicated the claimant was on a leave of absence, but it should have said he was suspended due to misconduct. Now, this is the first time the word suspended is used anywhere in the record. It does not appear in the EI Commission record. As case law, they cited this. Errors which do not cause prejudice are not fatal to the decision. And they're citing a federal court case here. I encourage everyone who had issues with EI to look at this themselves. This can be considered changing facts, which can be sanctionable, right? When your final decision is you're on leave without just cause, and then when that decision is appealed and you know you're going to lose because you didn't do the just cause test, to say, oh, we just made a typo. It should have said suspended due to misconduct. This is
It's
egregious, and it needs
It's
to be called out.
unbelievable. It's really unbelievable. People
Yeah,
are trusting what they have heard. Okay, you take leave of absence, no. And then they change it secretly behind the scene, calling you all bad names. Okay.
yeah, and a clerical error is like a typo. If you put July 1st instead of January 7th because you reverse the numbers, or you misspell someone's name, that's a clerical error. Changing your final decision, and the reason they did that is because people can dig into this on their own. Leave without just cause is Section 30 in the EI Act. By changing it to suspended due to misconduct, they actually changed the applicable section of the EI Act, which has a totally different set of tests and definitions. So this clerical error was actually changing your final decision, changing all of the analysis that must go into it, and then saying, oh, you don't have to consider it because it's not fatal. Don't look into it, just accept the fact that there was a mistake. So we'll leave it there, but that's an important one that I think other people should check their own documents to see if that also happened in their place. So now we're leaving Service Canada and we're going to the tribunal. So a brief background here. The tribunals had a bunch of different iterations, and around 2014, they went through a major restructuring where the law was changed, the form and rules changed. They went from being a board to having tribunal members. And they had a multi-year study from KPMG, a major business corporation, who analyzed all the different problems that were going on and proposed solutions, right? How do we improve the tribunal for Canadians? One of the things they did is built a new tool called Atrium, which is a case management tool for following the flow of cases. I want to just read something from a report from 2018. These date codes, the first two numbers is the year followed by the month. So this report was issued in July of 18. Between fiscal year 16 and 17, the tribunal launched 5 new releases of its case management system called Atrium. Capacity was also enhanced with new features like assignment tools to transfer cases back and forth. Here's an important one. Efficiency was further improved by developing decision templates pre-populated with legislative text related to the issues at hand. So we're going to look more at this later towards the end of this section, but they have templates are pre-written paragraphs that already have case law and footnotes attached to it. So of course, if you're citing a case that requires a case to be dismissed and you're putting it in a template, by default, when you insert that particular template into your decision, it already is determining the outcome of the case. So again, this is important. They're claiming it's for efficiency, but what they're doing is they are pre-writing reasons that already have case law and footnotes that determine the outcome built into it. And then they click a button, or it could be machine learning. We don't know exactly how the templates are inserted, but somehow they have a library of templates that they will pick and choose from to insert into their decision. And this is important because, again, 2/3 of tribunal members do not have a law degree or legal background. That is a quote from the tribunal's website itself. So I just want to pull a couple. They have different reports they issue. And I want to just discuss a couple of points about how these templates work and how they're received. First, they talk about plain language. There's 3 reasons they give for these changes. One of them is to increase capacity and efficiency, to make things flow faster, to get more cases out in a time period. The next one is readability and consistency. People were complaining that I don't understand legal terms or the decisions contradict each other. So they wanted to standardize their decisions. And of course, they wanted to give plain language training to make things simpler. So plain language training is about clear communication. How you design your decision is important. The wording, structure, and design all contribute to readability. So there's your pretext for plain language. Here's how they describe templates. A solid structure will serve as the backbone for your decision. Recent decision templates in Atrium give you solid examples. So they are saying these templates form the backbone of the decision. Here's another one, and this all comes from the style guide. Decision templates help you with readability. Here's a command. Make sure you use the most recent decision template. Use templates so that your decisions are consistent with other decisions. Why? Because decision templates have benefits. They often set out the legal test. So here again, both in the report and the style guide, they are saying their templates, which you must make sure you use, set out the test in advance. Now, they did a study of how effective these templates were. They had 15 months where they trained people on templates, and then they studied the differences in their writing. And the sample size here is the whole tribunal. They didn't pick a couple. So here's an evaluation that took place. Tribunal members first received plain language training in January of 18, then subsequent sessions of supporting tools, and 15 months of practice before this study began to sample their decisions. This is really important here. Some tribunal members expressed challenges in applying training recommendations, particularly those delivered by non-legal professionals or those inconsistent with templates or internal messaging. When they were done this study, they surveyed the entire body of tribunal members and asked them this question: what additional training or support would you like? The number one problem, 48%, 24 out of 50 tribunal members said, I need help with decision templates. Why? Well, when you have templates that are inconsistent with training, or the templates are inconsistent with the internal messaging you're receiving, like in policy memos, what do? So I just want to highlight this as put this in the back of your mind as we go through the next sections. The next thing we're going to look at is case law. So of course, tribunal members are bound by federal court decisions. They're not bound by their own internal decisions. So something new happened here in the pandemic, which has two parts. They found 5 cases. Now, just as background, there were about 500 federal court decisions that came out on EI since the EI Act changed and the tribunal came into effect. So they found 5 cases that they used out of context and cited them 2,500 times, and they put these cases into templates. So you can see here a list of the names, the paragraphs, and the number of times they were used. These are important because in all 5 of these cases, the claimants admitted to breaking their contracts. So just an example, Lemire, he was selling contraband cigarettes at work, which is a criminal code offense, and it was cited 110 times. So in all 5 of these cases, the judges explicitly said, hey, this is why we're denying your EI. You broke your contract. And in all cases but one, they actually broke some sort of provincial legislation or the criminal code as well. After citing what these 5 people did, the judge says, we are not going to investigate the employer because you broke your contract. Right? If I willfully break my contract, there's no need to investigate what happened. So here's a brief example. If I'm accused of assault and I stand before the judge at arraignment and I say, Your Honor, I'm guilty, there is no trial. Because if you admit to being guilty, then you make your plea agreement, but you're not going to investigate the situation because you're admitting guilt. If you say to the judge, Your Honor, I'm not guilty, I didn't do this, the very next thing they do is schedule a trial, right? We have to fact find. We have to cross-examine. We have to determine whether or not you actually do what you're accused of doing. So the tribunal, or whoever develops the templates, found 5 cases out of 500 where the judge says, we're not going to look at what your employer did. Why? Because in all 5 cases, they intentionally, willfully broke their contract and some sort of legislation. So in all 5 cases, misconduct was proven, right? why are you investigating if the person admits to guilt? So they pulled this out of context. They pulled this sentence that says, we will not investigate your employer, and they put it in templates, and they spit it out 2,500 times as justification that, hey, anytime the word misconduct comes up, look, we found a case where the judge says we can't investigate your employer, so we're not going to investigate the employer, even though the EI Act requires them to consider whether or not your employer acted contrary to law. And the most important thing about this, if this stands, our case will become precedent that from now on, anytime anyone at the tribunal attempts to do this, they're going to point to our case and say, hey, look, in DA versus Canada, the courts looked at it and said, that's okay, that's perfectly acceptable. Now, this could be considered abuse of process. Here's a quick definition. To abuse the process is to misuse or pervert regular court processes, not justified by the underlying facts, to gain an unfair advantage. When you take a sentence that says we're not going to investigate your employer, and you remove it from its context and say, hey, anytime there's a claim of misconduct, we can't investigate your employer, that's abusing the process because the EI Act requires them to look at that. And here's the Supreme Court in Baker. If claimants have a legitimate expectation that a certain procedure will be followed, this procedure will be required by the duty of fairness. So the EI Act says you must look at whether they acted contrary to law. Baker says if you don't do that test, then you have violated procedural fairness, which is grounds to overturn your case. And the example I gave, guilty pleas don't result in trials. If you admit that, yeah, I know what my contract says, I broke it, that's it. If you say, no, I'm not guilty, then by definition, there must be fact-finding to determine whether or not you're guilty of what they're accusing you of. So again, these are all shoved in templates. So there's a reason for that. So we're going to look at the test. We just looked at the 5 decisions that allowed them to justify abusing the process. Here's the other half of it. So again, parity. One of the judges says the employer's conduct is not a relevant consideration. Why? Because parity was, he failed a urine test at work. It showed that he was either high or had been recently high. It's against his contract. It violates provincial health and safety. He worked on the oil fields with heavy rigs and cranes. They fired him. So this brings us to the misconduct test, which has logical fallacies in it. The Supreme Court makes it clear in Vavilov that reasonable decisions must be rational and logical. The rationality of a decision can be questioned if they exhibit clear logical fallacies, like circular reasoning, false dilemmas, or absurd premises. So here's the 4-part misconduct test they apply to us. Did the claimant willfully violate a clear policy, knowing the consequences? Now, just to be clear, there is no such thing as a misconduct test in EI. Over the years, different judges have found different requirements. For instance, if your actions aren't willful, it can't be misconduct. If the policy wasn't clear, it can't be misconduct. If you didn't know what the result would be, or the policy wasn't applied consistently, then it can't be misconduct. So this test was meant to protect people accused of misconduct by saying, hey, you have to meet all of these elements, and if any one is not possible, then you're not guilty of misconduct. We're going to look at how this plays out. Here's a syllogism. The employer terminates a worker alleging misconduct. You broke your contract or policy. In misconduct cases, apply the test, the 4-part test, with something new for the pandemic. Ignore the employer's actions. How? We just looked at it, right? They pulled that paragraph out from these 5 cases saying the employer's conduct is not a relevant consideration. So they tacked that on. And if the claimant meets all 4 parts of the misconduct test, then they're guilty of misconduct and denied benefits. They're missing the word alleging here. This is where it becomes a logical fallacy. So I provided examples. we talked about an employer who implements a policy saying all employees have to work 24 hours straight with no breaks because we have huge productivity problems. So let's apply this modified misconduct test. The employer terminates X, alleging, hey, you only work 12-hour shifts, not 24. In 12-hour shift cases, apply the test, and new for the pandemic, ignore the employer's actions. Claimant meets all 4 parts of the 12-hour shift test. Therefore, X is guilty of working 12-hour shifts, 60-hour work weeks, and he's denied EI. This is absurdity, right? It comes down to ignoring the employer's actions. They've tacked that into the test. And that actually is a logical fallacy. I'm going to quickly switch to presenter mode so that we can see the definitions of these two. So begging the question, or petitio principii, is an informal logical fallacy that occurs when the argument's premises assume the truth of the conclusion in the body of the syllogism. So for example, if we say at the beginning that all cats are black, and then we arrive at the end and say, therefore, all cats are black, we've never actually looked at, are cats black in the middle? That's petitio principii, because you've just assumed the premise in the conclusion. Here, the employer terminates a worker alleging misconduct. Hasn't been proven. They do this test, which abuses processes by intentionally not looking at what the employer did, which is required by law, and they come out to the end saying, therefore, you're guilty of misconduct. So they have assumed the allegation of misconduct, and nowhere in this 4-part test are they looking at, is it lawful to lock someone out of their job? Is it lawful to coerce an irreversible medical treatment against people's will? They're purposely sidestepping that by tacking these 5 cases into the middle of the test, saying, yeah, we're not going to look at whether your employer broke the law. So this is important. This is a logical fallacy that undermines the logic. If this green part here, ignoring the employer's actions, was gone, you would run through the employer terminates X, alleging 12-hour shifts. 12-hour shift cases apply the test. Okay. Did the employer act contrary to law? Yeah. Employment standards say you can't work more than 13 hours at a time. So therefore, they fail the test. The other one is special pleading. Special pleading is an informal logical fallacy where a person claims an exception to a general or universal principle, but the exception is unjustified, double standard. What we're looking at here is the universal principle is the EIX says you must examine whether your employer acted contrary to law. And they're saying, yeah, but if there's an M in your record of employment, we don't have to do that. Well, where is that in the law? You are adding something, an excuse to say, yeah, we don't have to do what the EI Act says. Why? Because I found a paragraph in a case somewhere where judges we don't have to investigate the employer. Right? They found 5 cases out of hundreds where the judge says, we're not going to look at what the employer did. Well, why? Because you admitted to breaking your contract. They pulled the sentence out, shoved it in templates, and then used it as justification to change the misconduct test. This is absurdity, right? What they're really saying is, I'm sorry, Mr. X, we cannot consider your employer's unlawful actions. Why? Well, because you committed misconduct. And we're saying, but wait, the only reason I'm supposedly guilty of misconduct is because they broke the law, right? What they are doing is they are determining your guilt in an alleged misconduct. Instead of looking at the allegations of misconduct, they're determining your guilt based on the company's unlawful actions, while simultaneously saying, hey, because you're guilty, we can skip the statutory requirement to investigate whether your employer acted contrary to law.
We'll have to wrap up soon this presentation, and we'll discuss more about this code M, because I have a letter from one of the employees where they said it's for sure it was administrative leave. It has nothing to do with misconduct. Your misconduct is not mentioned, but your ROE mentions code M. So for employer, even they write it in writing, No, it was administrative. Nothing was related to your misconduct or bad behavior. But on paper, they put M, and it has become a trigger to essentially to deny all support from employment insurance. So I'm just looking at the time, Matthew. So let's say about 10 more minutes. I think we still have.
Yep. I just want to examine the templates, and then we're good for this presentation here. Then we can spend some time looking at solutions. So again, they've created an escape catch. Anytime you put an M in a record of employment, you've made it impossible to qualify for EI, even when they break the law. So I want to quickly look at how these templates work, because it's one thing to explain them, but when you see them, it becomes much more clear what happened. So I'm going to switch my sharing here. Stop sharing, and I'm going to pull up my screen here. And we're going to look at the templates for KVP. So again, KVP was a labor arbitration test that set out 6 requirements. The 6 requirements were that if you were going to deny someone EI, or if you were going to find someone guilty of misconduct for a policy that was unilaterally imposed, you had to look at 6 conditions. Number 1, it must not be inconsistent with the collective agreement. And number 2, it must not be unreasonable or unlawful. Of course, this was both, right? The Supreme Court codified this labor law test across the country in Irving, saying any rule or policy that is unilaterally imposed by an employer and not agreed to by the union must be consistent with the collective agreement and be reasonable and lawful. Let's look at how these templates worked. So you can see I've got a search here for anything with the word KVP in it, and anything that says unilaterally impose or unilaterally bring in, and even if the union disagrees. And as you can see, there's 10 search results here. In a unionized setting, an employer may unilaterally bring in new policies or rules, even if the union disagrees. This is what is known as the KVP test. You can see here.
Yes, yes.
This exact same. The test arises out of Arbitrator Robinson's decision.
Yeah.
The test arises out of Arbitrator Robinson's decision.
Yeah.
You can see this same thing happens over and over.
Yeah, exactly the same phrase, exactly the same case mentioned. And as you have highlighted, this case is irrelevant.
Right.
And I have a warning. We have 10 minutes from now, so let's make sure this is very important. So they used irrelevant cases, and they automate the process. So they remove the human decision. Essentially, the human, there is no more even opportunity for a human clerk in employment insurance to do anything. And I've seen this issue everywhere. Like everyone is just doing their job. They're just following the instructions. The process is already established. You just come to work, you push the button, and another life is wasted.
And it's even worse. I agree, that's really bad, but look at the next thing I'm going to show you. So these templates are all cited by tribunal members to justify denying EI, because in all these cases, the claimant said, hey, my employer unilaterally imposed a policy on me that broke my contract. So they came back and said, no, they can do anything they want, even if the union disagrees. But there were a lot of people that said, hey, I read KVP. KVP says you can't find me guilty of misconduct if the policy violates the contract. So they have a bunch of templates saying this. These templates totally contradict the other ones. So here's another long sentence. This legal test was developed in the context of employment and labor law, and I didn't find it helpful in interpreting the EI Act. you can see the same thing happened here. And there's more. So they had templates that directly contradicted each other. If someone says, hey, like they broke my contract, they use a template saying, sorry, KVP gives them that right. If someone said, hey, KVP says you have to examine whether the policy broke the contract, then they have a template that says, yeah, but this legal test came from labor law and it's not helpful in determining EI. So they can pick the contract they want that gives them the decision they want. And it also applies to footnotes.
Interesting. I found that our union legal office is also sending very similar responses to all our members. I received dozens of complaints from members where the union essentially didn't want to support their grievances, recommending against filing grievances. And it seems like they're using exactly the same template, exactly the same cases. And in fact, we're going to have a separate session examining those cases which are used by the union, because members have no legal background, and the union tells these 5 cases are telling us that you have no way of winning, so we are recommending against filing the grievance. That's it. And they're doing it on using our membership money, which we are paying for them to do that against us. It's unbelievable, but that's how the union seems to be working and using our money against us. Okay, your slide here.
Yeah. One more screen after this. I just want to show the templates also apply to footnotes, right? So they have a case that says this is why KVP does not apply EI misconduct. And you can see this is footnote 2.
Yes, yes.
This time it's footnote 12. This time it's footnote 15.
That's right.
Right. So everything is blocked together. The KVP test includes footnotes and case law and citations. I just want to show the results of this. As you can see, there were 24 cases that cited KVP between 2022 and 2024 December. So that 3-year period of mandates. I want to show you something. Appeal dismissed. Application for leave to appeal refused. 24. Look at this, 24 results. Every single time KVP appeared in a case from 2022 to 2024, it resulted in the case being denied. And you can see the template over and over and over and over.
It's automated. The whole process is fully automated. Yes.
Right. They're reverse engineering. And according to the Supreme Court, reverse engineering decisions is not acceptable. It can result in your case being overturned.
So we have maybe less than 5 minutes now. Yeah. Let's see.
So we're not going to discuss this. This is the last error in the case. The EI Act describes how EI is paid. And of course, we talked about the fact that EI is not paid by the government. It was a judge who made a mistake in this case in 2007, saying that it is not acceptable to transfer the cost of EI benefits to taxpayers. This case was cited 160 times. Again, people can walk through this on their own, but taxpayers don't pay for EI. And yet 160 people were denied EI, saying, hey, even if your employer did break your contract, it's not fair for the taxpayers to pay for it. So that's it. That brings us to the end of our conclusion. We've looked at the big picture, we looked at the problem they had to solve, and we looked at how they've engineered processes all the way through to come to a decision of misconduct, no matter what happened.
So just to recap, who is paying for EI benefits? Is it the employer?
It is split between the employer and the employee. 58% is from the employer and 42% is from the employee, and that is right in the Act.
So not taxpayers, bottom line.
The taxpayers have not paid for EI since 1990 when Bill C-21 came out and removed taxpayer contributions.
So essentially, that was a misleading statement, and I've heard it myself also, that we just cannot afford doing that because taxpayers will have to pay for those millions of people on leave without pay.
Exactly. And I'm sure the judge meant well. For generalist judges, he doesn't study the EI Act. This was obiter dicta. He was just making this as a side comment. He didn't deny it for this. He was making a side comment that, yeah, even if that's true, it's not fair. And then, as you can see, that was cited 3 times in 6 years. The pandemic comes, 160 times that was used.
That's right. I see.
Did you have any questions you want to discuss in the last few minutes?
So what is your next step? Again, what are you trying to achieve right now with such a very clear presentation? You have shown that, in fact, the role of the human decision-making right now is practically removed. So the whole process has been crafted, automated well before even the pandemic to manage cases which are, we can ask the question, who benefits it? Who drives these processes? What is the force behind it? So you can probably answer this question, like who developed it? What was driving this automation? And what would be the next step?
Yeah, so I think we can get into the details in the next recording on solutions. But in general, we've found 15 errors that were strung together. Processes were engineered which coerced or incentivized people to break the law by following new processes and using tools that automatically determine the outcome of their case. This is a serious problem, right? $13 billion, hundreds of thousands of people's lives were destroyed. If this case does not get public attention, this will become precedent. We cannot have these errors being precedent so someone can cite DA versus Canada to justify this in the future. So what we're looking for is people sending pre-written letters. We'll talk about this more later, but sending letters to the courts and to the people in government who are responsible saying, hey, this is not right. We need to have justice here.
Remind us, please, when is your case, when it will be heard? Do you know already the date? And
we are just waiting for approval, but it's supposed to be the 2nd week of February.
Okay, so maybe just closer to this meeting, we will have another Zoom discussion with you and invite everyone possibly to join to listen to this historical defense. So thank you very much, Matthew. This is unbelievable professional approach to examining, to reverse engineering the whole process. Because indeed, you need to understand how the machine works. And again, we will just meet for the Q&A in a separate session. So I thank you everyone who watched this episode. Please watch the next one too. Thank you.